Good morning. Can everybody hear me okay? I can be a lot louder if I need to. I'm a softball coach by passion rather than trade. I can yell, but I prefer not to have to do that this early in the morning. Thank you all, as I mentioned earlier, for being on time and early. I'm impressed. I live by the motto, if you're not 5 minutes early, you're already late. I can thank my college softball coach for that philosophy as well. My name's Lauryn McAlister. I'm a National Service Account Manager with Wolters Kluwer Lean Solutions. I've been with the business for 21 years. I know everybody looks at me and they're like, that's not possible. But I actually started in college. I did a little bit of everything within Lean Solutions. The great part about that is that I have done all of the various pieces of the work that supports lean perfection and the loan securitization process. And that's actually what we're going to talk about a little bit today, is focusing on the 5 things you can't afford to overlook when managing your lean portfolio. And, all right, clicker's not going to work, so I'll have to come back to home base. All right, so as I'm sure everyone here is familiar with, lean perfection is critical to modern lending, right? As I tell everyone that I know that has no idea what it is I do and why it's so important, if lenders can't secure, they're not going to lend, right? And we recognize that a lot of this causes immense stress to our customers, right? Lean perfection impacts your ability to collect if something goes wrong with the loan or with your borrower. And we want to and try to support that whole process. The lean perfection process, even though it's called the Uniform Commercial Code, it's still not uniform from jurisdiction to jurisdiction. There's idiosyncrasies that can impact what you do and how you do it. And of course, as I'm sure you're familiar with, there are plenty of things that will trip you up throughout that whole process. So you have to be careful, all right? And we're going to talk a little bit about what those 5 key things are, ways to mitigate that, and then open it up at the very end for any additional questions you might have. Okay, so as I mentioned, we're going to walk through the existing UCC process. Very high level. We're not going to get too into the weeds. Introduce you to the 5 critical things. And then, as I mentioned, make sure you're familiar with ways to avoid letting the things trip you up. And I apologize, I've got a 6-year-old and a 9-year-old at home, so Dr. Seuss, his birthday was last week, so Seuss has been on the mind, and I love thing 1 and thing 2. I've got 2 of them. Okay? So first and foremost, naming, right? When we're talking about naming, what we're really talking about here is the debtor name that you're putting on your filing, right? That's your first step in lean perfection. If you don't get that right, you've already failed, okay? And there are certain jurisdictional wrongs that go along with that. And then one of the most important things is understanding the Uniform Commercial Code, what it does, what it dictates, and how it acts. Right? And there are some basic rules of thumb when it comes to business entities. Everyone's got that one, I want to say, pretty wrapped up, right? You use the name as it appears on the Articles of Organization. And you file in the state where they're organized. And hopefully everybody's nodding and saying, yes, that's exactly what we do, thank you. Because that's crucial. The big area that provides a lot of heartburn and headache for customers today is in individual names, okay? And we wanted to share a particular case that had some impact. This particular case is Ronald Marked, with a T on the end of Mark, Ney, versus Leaf Capital Funding. Essentially, Leaf funded 2 large capacity dump trucks to Ronald Ney and his wife. Shortly after they had done that, the gentleman and his wife declared bankruptcy, and Leaf entered into the process to try to recoup their losses on the dump truck. The problem is that the gentleman's name is M-A-R-K-T, his middle name. And that T on the end is a big difference between perfection and imperfection. Leaf had filed Ronald Mark, no T, Ney. And ultimately what the courts determined was that that difference in that middle name was the difference between perfection and imperfection. Okay. They actually separated Search or Safe Harbor from the equation and said it didn't matter that you could find it. You had not met, you being Leaf, their due diligence needs to perfect the name. Okay? And therefore they lost position and actually lost their ability to collect because the sale of those 2 dump trucks paid off the creditor who then had first position. Okay? So individual names can, as you can see, cause a lot of heartburn. Okay. When I'm training customers, I talk about my boss, or one of my former bosses, whose name is James F. Andersack Jr. When we do searches, we look for variations, right? So that you're aware in the underwriting process of what you're looking for. We look for Jim, Jimmy, James, Jamie, the letter J, with and without the F, and with and without the junior. But that's on the search side, right, where you can know about everything that might present risk. The key here is that on the filing side, if you don't get it absolutely perfect, you could put yourself in a position to lose, okay? And ultimately, what you're doing with the lien is to win in court should you ever have to go to court. The easiest fix is to use the name exactly as it appears on the driver's license, okay? Everyone, I'm sure, has heard about Alternative A and Alternative B. I'm not going to go too into the weeds with that. I'm not an attorney. This is the rule of thumb that is the best practice for ensuring you get the correct name. Okay. And it's typical that most individuals are going to have either a state-issued ID or a driver's license. Okay. Birth certificates can differ. My birth certificate says Lauryn McAlister. I've gotten married. My given name now is Lauryn McAlister Bary. Right? That can be the difference between winning and losing in court. Okay. Next key area, and this is probably the most troublesome, right? I'm sure you all have very wonderfully established due diligence processes to get the name right on the front end. The second factor is what happens after, right? Because the UCC is good for at least 5 years. You continue it, you add another 5 years, and a lot of things can change with your debtors in that time frame, okay? Have they changed their name, merged, dissolved, or lost good standing? Did somebody terminate your filing without you knowing? Okay. You might know, but you might not. I have a lot of customers I've worked with over the years who tell me, well, it's in our paperwork. The customer has to come tell us. And I ask, well, do you define how quickly they have to come tell you? And the answer I usually get is, well, no. Is it important? It is. You have 120 days from the time a customer changes their name to amend it on your filing to have filing perfection. 120 days in the business world goes by really quickly, okay? More often than not, your customer probably doesn't even realize the importance of telling you, and by the time they get around to telling you, you're already at risk. Okay? One of the things that we strongly recommend is monitoring your portfolio, okay? You want to look for changes. Key changes you want to be aware of: debtor name and status changes, right? Those are typically the largest headache or concern that our customers have. Did our debtor change their name? Did their status change? Okay. Name change, obviously very important. Status change is also usually a red flag. If they have had an adverse status change, there's typically something else that they're not doing right that could impact their ability to stay organized as an entity, which could impact your ability to collect. Okay? And then, of course, subsequent UCCs. And what we're talking about here are UCCs filed against your filing that you did not authorize or aren't aware of. But also UCC ones filed after you, right? If you did your due diligence, customer had no UCCs on record, right? That doesn't mean that that hasn't changed. And every time that they take out a loan and a UCC is filed, that impacts their ability potentially to pay you. So your risk grows with every additional lien that's out there. Okay. The other thing that we've discovered is that a lot of our customers are not aware of every filing that they have. Okay. Law firms, if you have law firms that are closing loans for you, how quickly are you receiving those filings back? How are you getting them into your portfolio to track? Are you tracking them? And we just like to pick on law firms because they're usually one of the slowest groups that support the loan closing process that present headaches for our customers. Okay. Third item we're talking about here is leveraging a UCC3. Okay. UCC3s are vital. Loan goes longer than 5 years, you have to continue it. Debtor changes their name, you have to amend it. You change your name, you may want to consider amending the filing. Collateral changes, you have to amend it. Okay? UCC3s are as I mentioned, a vital piece, but they're also a way that changes the organic structure of the document. Okay. One of the most crucial ones to our customers, obviously, are continuations, right? They give that filing another 5 years of life. And one of the areas that we hear the most concerns about is, well, how do we know when to continue them? We're not sure if we're continuing everything we need to be continuing. One of the areas that we recommend that you consider offsetting that concern or that risk is in automation. Okay? Automating continuations based on loan balances and things like that. Okay? We actually have a customer who filed about 30 to 40 continuations a month. Okay? They came to us and said, we had a lapse. What happened? Well, first and foremost, they actually had 2 lapses, 2 filings for the same customer. The first one lapsed because their individual who was responsible for submitting the continuations was out for a period of time, and no one picked up the process while they were gone. Okay? The second one lapsed because they didn't know about it. It was a law firm filing, and the law firm had never sent them in their loan package a copy of the recorded UCC. Okay? So they came to us and said, help. We said, great. We can automate that process for you. Populate a portfolio of your public record filings. You tell us which ones not to continue, and we sweep everything else and push it out automatically. That way, Susie is out of the office again for any period of time. It doesn't fall through the cracks. Okay. And with that, we have another lender. This is a national size lender who experienced greater efficiency. They reduced their FTE that was consumed in managing their continuation process by 75%. Okay, that's a massive amount of resources. These were subject matter experts who spent 3/4 of their time doing continuations. Okay. They were able to allocate those resources to handle other key pieces of the process to subvert their risk. Another key area is that all states are not the same. Okay. On the UCC form itself, the majority of the information is the same. You've got 2 key states that have additional tax-related questions you have to answer. Okay. You don't pay your tax amounts properly, it affects your lien position. Okay. But in addition, the other key thing is that states do not provide the same consistent search logic to allow you on the front end to understand your risk and ensure that you are establishing the appropriate lien position. I like to pick on Michigan. If anybody's ever done a search in Michigan or done a loan in Michigan, Michigan is what we consider exact name search logic, down to punctuation. You search on the Michigan Secretary of State website, and you have to search multiple times. You have to pay multiple times for your search. One of the things to keep in mind is that if you're funding for someone who is incorporated outside of your general footprint, ask, do your folks have the expertise to know these idiosyncrasies around search, getting it right on the front end, determining the name to use moving forward? Okay? I guarantee you they don't. And they shouldn't, right? You have a footprint, they learn your footprint. You go outside the footprint, and sometimes you have to, right? You have to file in a state of organization for your debtor. Okay? If that's outside of your footprint, now you're in uncharted territory, okay? And I don't know about you all, but I don't like being in uncharted territory. Okay? So make sure that you've identified some of those pitfalls. You've got the right training to support, documentation to support the appropriate processes across all 50 states. They're not uniform, they're not the same. Okay. And like I said, I pick on Michigan all the time. Michigan presents incredible headaches for our customers. And one of the ways that we offset that is to provide what we call generalized search logic, meaning we aggregate data directly from the jurisdictions as often as possible. We put it into a searchable database that allows lenders to use the same consistent search logic, same processes, same platform. There's no maintenance of ACH accounts. right? Georgia, I like to pick on Georgia too. Georgia has unique logins per institution. You can only have one individual, one login under that ID at any one point in time. Okay? If you have multiple individuals who are to log into the Georgia GSSA site, they deactivate your ID. And now you're done, you're stuck. You can't do searches. And it takes anywhere from 1 to 3 days to have your ID reactivated. Okay? These are the types of things that can trip you up. Slows you down. You can't do your due diligence to verify entity name or verify risk. Okay? These are the types of things that can present significant problems. We've had customers come to us saying, we're not going to do this jurisdiction ourselves anymore because it requires an ACH account and we keep spending the money that we can get authorized to put on that account, and then it takes 2 to 7 days to reload the account. Now we're stuck. Okay? By creating that platform or database of searchable logic, consistent format, consistent search logic, we don't cut you off, right? You don't have to advance fund fees. Gives you that consistency so that you don't have to worry about whether or not your folks have that subject matter expertise in a given jurisdiction. You don't have to worry about searching 17 times in Michigan to include any and all common sense variations. Okay. These are major pitfalls that can impact how quickly you can get your customer to close, but also whether or not you have the confidence that going to closing, you've done everything you need to do, and you've got the right information to secure it after the fact. The last pitfall is kind of a general item, right? And that's that perpetual presence of risk. Okay? We all know filing the UCC is just the first step. There's a level of due diligence and maintenance that goes into it. Okay? You have to know what has happened and what hasn't happened. You have to look for things like wrongful terminations, lapsed filings, and debtor information changes. Okay? I like to talk immensely about wrongful terminations. Okay? They happen all the time. I'm not sure if anybody is aware, but revised Article 9 provided debtors with the ability to terminate filings. They supposedly don't have the same weight in court that a secured party termination does, but when you're doing a search, it doesn't say debtor termination, secured party termination. It says termination. So as a lender, you see that and think, terminated interest. It affects lien position, right? Okay. In addition, there's always the possibility that somebody else terminates your filing. Or, picking on those law firms again, a law firm terminates your filing. Okay? The example on the screen here is associated with the General Motors bankruptcy. Okay? There's a lender who had 3 key filings that were at risk in this motion. And in the restructuring, the agreement was that one would be left alone and the other 2 would be terminated to be reworked under the reorganization. Okay? Instead, that law firm terminated all 3. It went through a level of approvals process. Somebody on the lender's side looked at it. That person on the lender's side didn't even know what a UCC was. So when they said approved, they had no idea what risk that they were subjecting the bank to. And what that meant was that the one that was supposed to be kept secured a $1.5 billion loan. And the lender lost out. They were deemed to have no secured position as a secured creditor. So they fell in line with all the unsecured creditors after the fact for $1.5 billion of loss. I'm hopeful that you all don't have $1.5 billion loans in your portfolio too often, okay? But how much risk can you support with wrongful terminations? And then the question becomes, how do you manage that within your existing processes to know if somebody has terminated your filing? Okay. We talked earlier about monitoring. Okay. One of the key things is, first and foremost, you have to know what you have on public record. And you have to know what happens to and with those filings. My favorite instance is a captive finance lender who figured out that a bank terminated a very large loan of theirs because the bank user, in creating the determination, transposed two numbers. It was an electronic filing jurisdiction. Jurisdiction didn't look at the secured party. They don't care. They took the filing, and they terminated the captive finance lender's filing. And it was terminated, whether correct or not. Okay? That captive finance lender's only recourse was to file a UCC-5 correction statement and refile a new UCC. And then hope, first of all, nothing goes wrong with their customer. And second of all, if they go to court, that they've taken enough steps to reestablish their lien position. Luckily, their customer just paid off that loan, so that headache is gone for them. But they have been doing monthly research for 3 years now to make sure that nothing happened with that customer, and harassing that customer to make sure nothing negative happened with them. Okay? So again, you need to monitor your portfolio, whether that's conducting ongoing UCC searches for your most business-critical loans, okay, and determining what size and scope of that portfolio is, or finding a third-party provider who can do it for you. Okay? So bringing it all together, name and jurisdiction are critical, right? That's where the perfection starts, but it's not the last step. Okay? Not only are they critical, but it's also difficult to manage, right? You don't necessarily know what has changed with your customers. You as a secured party have a responsibility to maintain that accuracy. You have a limited window of time to correct it should something change. All right, 120 days goes by really, really quickly. Okay, and if you don't know, it presents a lot of risk. Okay. There are a number of other pitfalls. These are the key ones, right? Name perfection, maintaining perfection, understanding the risk, leveraging those UCC3s to help offset that risk, okay? And then continuing that through the entire process. We understand and recognize that secured lending is complex today. It's only going to grow more complex. Okay? The search, file, and manage process continues to evolve. The 5 things we've talked about will rear their heads. I won't say can, they will. They are perpetual issues if you're doing UCCs. And if you want to be able to collect, you have to be doing UCCs. Okay? Ultimately, one of our biggest recommendations is to find a trusted partner who has the right resources to help. You don't have to do everything with that one trusted partner, but define what are your biggest areas of risk for your institution, and then work with that trusted partner to understand and offset that risk. Okay. Any questions? I've talked a lot. I hate listening to my voice. Nothing? County filings are only done against specific types of collateral. It's done against real estate. So county level filing is only if you have fixtures attached or affixed to a piece of property, or dealing with an actual piece of property. In that case, you file in the county in which the property is located. That also defines where somebody is going to search, right? So it doesn't help you to file in Alamance County if the property is in an entirely different state. Question. Also with individuals, right, we talked about using the driver's license to get the name right. That should also help to dictate where you're filing, right? Where they're doing business is not always the same place. Okay, so when in doubt, use that driver's license to determine where exactly you should be filing and what name you should be using. Mm-hmm.
You should be county and state? Is that what you're...
I'm sorry, what's the cattle filing?
Like brand filing. Brand.
That's a good question. If you don't mind, at the end, I want to reach out. We have a precedent team. I'd like to reach out to them and ask them a little bit more detail around that. That's one of those legal questions I like the lawyers to answer.
Simple to make sure we also have issues with the name.
Right.
Actually
It may be, so if you don't mind connecting with me afterward, we'll definitely get some answers for you on that one. Like I said, that's one of those we want the attorneys to weigh in on. And we actually, we have one of our key members of our precedent team has been a part of IACA, as well as the group that has written revised Article 9 and then rewrote revised Article 9. So we've been in the trenches helping to define the code, helping to refine the code, and make it sustainable across the industry. So he was a crucial part of the defining individual names, defining business names. I've been around in the industry so long, I still remember when, if John Deere had a filing, they would file where the customer was located. They might file in Iowa where they were. It didn't matter. So you had to search multiple places, multiple ways to find and define your risk. RA9 helped to at least give you a little better direction.
I have a couple more questions.
Sure.
So is there, or maybe it could be a state legal law as well, once the loan is paid off or if a customer doesn't request for the UCC to be filed, a lot of the time we'll just let it lapse, depending where it's at. Is that legal? Is there a point where you should be? I know with like real estate, if they request it, you have so many days.
So it's a little bit state specific, especially when you factor in county level filings, because again, that's associated with real estate, so that falls into that gray area. There are some states that do have statutes about terminations. There are some states that have none.
One other question too is there any benefit to layering UCCs if it's not purchase money interest or anything specific on there?
Think about, that's more of a business decision to make. The UCC establishes lien position, but it also establishes what you have a right to collect against, right? What value. So layering really just sort of says, okay, when this one's done, here's the next piece. What a lot of our customers do is just amend the original because it has that premier or preferred lien position to reflect the current scope of the collateral versus filing new ones. PMSI is still just a UCC, right? All it's going to do is give you that process to leapfrog over anybody else for the specific collateral if you've done all of your X, Y, and Z that goes into that. They were good questions. Any other questions? I know it's early. I hope everybody had their caffeine with breakfast. All right. Well, if there are any other questions, we'll give you guys a little bit of time before your next session. If you're in here, great. Hope you have a good seat. Otherwise, enjoy the learning labs.